So let's go through what you're going to argue to the judge and why your client should be released. Well, we talked before about that criminal justice agency report that they did in the back. This is one of the strongest things you can use to argue to the judge. This wasn't prepared by you or wasn't prepared by the prosecutor. This is a form that's filled out with, someone who's not picking sides. You say to the judge, the criminal justice agency recommended my client be released on his own recognizance. It's a very strong argument to make. You want to establish that your client has local ties. Why? Because bail is really there for making sure your client returns to court. Again, one of the reasons that they changed this law, because they were setting bail because of other things, not necessarily looking if the client would return to court. But you want to establish local ties. Do they have a home? Do they work? Do they have kids in school? Do they, if they lived in the community for a long time? These are people who are not going to flee and not respond to, their court date. You want to, if they don't have a prior record, you certainly want to establish that. And if they do have a prior record, you want to try to distinguish it in some way that might help you. And maybe they're lesser crimes, maybe they're a very long time ago. Prior warrants. That's truly going to be a problem. There's not much you can do if there are prior warrants. Everyone always has a reason why they missed court or whatever. But if you have someone there whose rap sheet shows, they missed court a couple times on a couple of cases, judge is going to be more inclined to set bail. You want to show that your client's not a flight risk. Again, that argument kind of comes with local ties and whatever else you could say about your client and why they wouldn't be. You want to argue the seriousness of the charges. If the charges aren't that serious, you can have, a C felony, that's very serious and that's not that serious. And you want to explain that to the court. And you want to talk about the strength of the evidence to the judge. And I'll tell you something funny that kind of happens. When the DA has a strong case, they will always talk about how strong their case is when they're making the bail application, and then I can respond to how weak I think their case is. But if they're saying it's strong, a lot of times it is. If they don't think their case is strong, then they won't say anything about the strength of their case. So then, of course, I start talking about the strength of their case, and then they object and they say, well, now's not the time to, debate the case and try the case, counselor. And I'm like, this is exactly the time. You want the judge to know the facts and what happened so the judge can make a good decision on the bail as opposed to just looking at what the charge is and going, ooh, it's a C felony, we have to set bail. You want to be able to explain the specifics to the judge. The damage or harm to a victim. Now, the reality is the damage or the harm to the victim shouldn't really have anything to do with whether or not your client is going to appear back in court. But the reality is that judges are swayed by this. The more damage there is to somebody physically, the more damage there is to someone monetarily, a judge is going to be more inclined to set higher bail. It's just a prejudice that it's hard to get out of their head.